A very good evening to one and all. Welcome to the first session, the certificate course on research methods and methodology, organized by the law learners. Uh, the course is on collab. The course is the continuance of the events in collaboration with the RGNLU Patiala. The event which is scheduled to be held from 12th of October. Uh, National Law Student of the Year's Award. Today's session will be presided by Professor Dr. Yugal Kishore sir. Sir is the Dean of ICFAI University, Dehradun presently, and has also served as the former VC of NLU Assam. Sir holds distinguished position and is an distinguished authority on environmental law as well as on research methods. Sir would be taking the session today. So with this, I hand over the session to Sir. All yours, sir.
Hello. Hello.
Yes, sir. Yes, sir. You are audible, sir.
So am I to start now because my some connectivity problem was there.
Yes.
So whenever I have to start, please tell me.
Yes, sir. You can start. You can start, sir.
Okay, now I can start. Okay, good.
Yes,
Then
sir.
good. In fact, because of the connectivity problem, I'm not capable of connecting it to laptop or other things. So I'm on my mobile phone, isn't it?
Yes, sir.
Okay,
Sure.
madam. So good afternoon to one and all. I'm especially the distinguished personalities present, that is different academicians, and the organizers and dear student friends. So good afternoon to one and all. I'm grateful to the organizers of the program, the Indian National Law Review, the law learners, and GNLU Patiala for inviting me and giving me this opportunity to speak before you a few words on legal research on this particular day. The organizers have provided me a good platform to showcase your professional skill in different competitions and free online course on how to do legal research. For that, I'm very much grateful to them. One thing, madam, am I audible or not? Hello? Am I audible? Just please tell me I'm audible, then I can continue. Hello?
Audible.
Am I audible?
Yes, sir. You are audible, sir. You are audible.
Okay, then I'm continuing.
Yes, sir.
So before I start, I pay my homage and respect to respected Gandhiji, the father of nation, and Shastriji, the second Prime Minister of India, on their birth anniversary today. So we are celebrating Gandhi Jayanti as well as Shastri Jayanti today. For me, if you look at, they were the greatest researcher, what we call them as the action researchers. Gandhiji, he started with his principles of ahimsa, which he himself have propagated, and with a new tool, that is satyagraha. And he talked about the truth. He had written a book on book also, My Experiments with Truth. So therefore, all his life was a research for him. Every day he was doing that research and trying to see that where he has failed in performing a good research on that particular day. And then this ahimsa, satyagraha, and other things during that tenure brought us to independence. So India is independent. It is said that it is because of the Mahatma Gandhi. Similarly, the Lal Bahadur Shastri ji, when he took over, India was in a very precarious condition. It has lost the war with China in the year 1962. And apart from that, the other aspect was that he has seen that India was suffering at the level of food security. So the food was imported from America and other countries, and the food which we used to get here at that time was not a quality food, but a food which they were providing to their horses and other things. So they were supplying to India. Looking at that condition, the Shastriji was very perturbed, and he started doing his research work. And with that, he gave a slogan. Not only a slogan, there's a principle. He started working on it. That is Jai Jawan and Jai Kisan. He said, if in our it will not be facing in future. And with the result, in the year 1965 war, of course, in that war we lost our Shastriji, but then we won it, and in due course of time, we have won our struggle for food security also. So they were the greatest policy researcher in India. You are mostly, I feel that I am speaking to my students at the UG level, at undergraduate level, integrated 5-year degree course. So you undertake projects. You are given projects by your teachers. And further, at the higher level, when you go to the final year or around, supposing you have taken some honors paper, then you go for dissertation. But then, if you are in a national university or in some reputed university, then from the first very day, everyone talks about that you should be research oriented. You should carry on your research. And now for you, at that time, you must be thinking, what is this research? What I am to do in that course of research? So you can easily analyze the word, the research. That means re plus search. So some search has been there now, and from that search, some truth has been found, some facts have been found, but then on that facts situation, you have to work again and find a new truth, find a new fact, find a new method of approaching that truth. So that is how we go for research. So for us, in simple way, we can say that research is to find out new facts or something about the fact, to know something new about a thing which is unknown, to contribute something new about the existing state of knowledge. So here, when you do research, then naturally you are enhancing the knowledge. That means you are trying to find out something new in that particular research. So if you are not capable of finding a new something new therein, then your research is not completed. So meaning of the research in simple way, you can say to search something new, or to investigate at your level when you are doing research. Then you investigate for something new. You inquire about the facts to get something new, and then you infer on it, you conclude on it. So how do you go ahead with? For that, you have to do the systematic research. That is what is here. Here it is written, the systematic investigation into an study of material and sources in order to establish facts and reach new conclusions. So research is a systematic investigation into and about some material facts and sources in order to establish some new facts, some new conclusions. So research is defined as the creation of new knowledge or to use existing knowledge in new way to create, to generate some new concepts, some new methodologies, some new understanding. This includes synthesis and analysis of the previous research to the extent that it leads to a new and creative outcome. Now here, I'm reminded of a very great judgment. I think you all must have read about the oleum leak gas case, in which the then Chief Justice, Mr. Justice P.N. Bhagwati Saha, has propounded a new theory, a new principle, a new doctrine, that is the absolute liability principle. And at that time, he quoted something. So of course, before talking about that particular principle, I will be discussing with you his quotation. I quote, "We have to evolve new principles, lay down new norms, which would adequately deal with the new problems in the highly industrialized society. We cannot allow judicial thinking to be constricted by reference to law as it prevails in England, or for that matter, in any other foreign country. We no longer need the crutches of foreign legal order." Now, this gives you the whole history. That means in the year 1985 and 86, when this judgment came, you can easily understand that we were depending upon the clutches of the foreign legal order, especially the British legal order. We were following the colonial era rules. Of course, we are still following, but then we have deviated from that time. And that is the initiation of a good legal research in India. In fact, you know this case of absolute liability principle. So in this case, in fact, hazardous substances and inherently dangerous substances were used by the entrepreneur, and it escaped by accident, and thereby a number of persons, they have been killed and injured. There were two cases simultaneously. One was there at Delhi cloth mill, and the other was that Shriram Food and Fertilizers at Kota. In both the cases, the situation was the same. Likewise, you must have seen a few days back in Visakhapatnam, where the gas has leaked and a lot of problem came up. So now, in this situation, the old principles which were given by the English people of law tortious liability for compensation, that were applied. But then the problem therein was, and the strict liability, which was propounded in Rayland versus Fletcher. I think you remember that 5 or 6 exceptions were there. So under that exception, the parties used to get themselves exonerated or excused. So for that reason, he was of the opinion that no excuses when you use an inherently dangerous and hazardous substance for your profit. Then you must take the peril also. You must take care, full care, to see that no risk, no hazard emanates to the people. And if some risk, some hazard emanates therein, then you are bound to pay for it. You are at peril and you must take care. So absolute liability of care was propagated. And herein only he talked about the very, of course, I'll discuss it at a later stage, but then here he said that we should not depend upon the foreign law or foreign clutches. In fact, history was there before also. So I would like to tell you a little bit that, in fact, you know very well that Bhopal gas tragedy has occurred. And in the year 1984, and wherein a number of persons, in thousands and thousands, they have been killed and they have become sick and injured. Many cattle, many animal and agricultural land was affected. Environment was very badly affected. But then, when we thought of law, we were not having proper laws, and the compensation amount which India, was awarded at that time in India, was very less. So therefore, many persons, they filed a case in abroad, thinking that Union Carbide Corporation of India, from where this gas has leaked, is a subsidiary of a main company, Union Carbide Corporation of America. So they filed cases in America. And in our government was also lured as a parent, patri parent of every citizen of India. They also filed case there. They sent the Palki wala there to represent the case. And therein, they said that forum non-convenient. This is not the forum. Why do you come to America for a case which has occurred in India, for which law is there in India, for which situation, for which victims are there in India? Why do you come to us? Your Union Carbide Corporation has been registered in India. It's an Indian company. Of course, we have provided know-how. We have provided techniques. We have provided technology. We have initially provided some finance also. But that doesn't mean that we are the responsible for everything. So, therefore, under the category that convenient forum non-convenient, the case was dismissed. However, they agreed that in case of need, they will be representing themselves in Indian court. So therefore, we found that there is no law. And our Justice P.N. Bhagwati Sahab, he was going to retire. So before retiring, looking at the plight of the victims of Bhopal and other places where who have suffered loss and loss of life and loss of property, loss of job, loss of environment, he thought it fit to create this particular liability concept. So thereby, and said that whenever need arises, we should be ready to undertake the research and come forward with the new principles, with the new liability concepts, with the new methods. And so that was the beginning of a good legal research in India. Of course, in India, we had earlier also Indian law issued where research was done, and researchers, they used to go there for doing their research. But then it was not all. But a good research was not done at that time in India. We were always basing upon the research which has been followed by the foreign countries, and we were just adding something, and research used to be done. So anyway, so here, by the time when these hazardous chemicals, they escaped, and this has occurred, we came to know that law is multidisciplinary and multi-dimensional concept. So here the law plays a role. Biological species, they play a role. Law works in society. Law for law, technological inputs are very important. Sociology is very important concept because we are dealing in the society. Psychology, because we talk about the human norms, normative behaviors. Psychology is very important. Anthropology is important. Market forces are important. Economy is important. International order is important. So we came to know that that all these things we have to consider when we do a research in law. Now, what is research? Again, we will continue with that. That research is a scientific procedure wherein a systematic study is made. So now here I'm reminded of the Bentham. You know, Bentham was a great jurist who has propagated his theory of pleasure and pain, individualism, utilitarianism, and others. So I am here. He propagated his theory of utilitarianism, pleasure and pain. So he said that everything is having utility, and he measured their utility by pleasure and pain, which is inflicted by that on the society. And then he came forward with the legislation. He said, legislation is a science which should be based on a fixed and scientific principle. And when he was asked, what is this scientific principle? Then he said that, that the pleasure and pain theory and utility principle. By utility principle, he meant that the greatest happiness of the greatest number. So he said that the greatest aim of the legislation, the greatest the consideration for any legislation should be the greatest happiness of the greatest number, and it should be measured. If you are passing a legislation, you should do research and see that how many persons are getting pleasure, how much pleasure, and both the things, how many and how much pleasure they are getting, and how many persons are getting pain and how much pain, and then you compensate it. And if the pleasure and pain they are equated, then happiness comes in or sorrow comes in. If we are capable of providing happiness to the people, maximum number, then it's a good legislation. And then he said that individualistic trends, he propagated the theory of individualism. And he said that let the individual be free, through contract he will develop. Because all these regulations, they bring him to some restrictions or the other. And these restrictions, they are pain. They are pain. So pain should not be inflicted upon him. And therefore, a privatization, the type of thing developed therein, and individualism developed in England at the in the initiation of the 19th century or that. So now the problem came up because of the individualistic trend. It so happened that persons, when they were hired by the industries, they were asked to work more and more. And when they opposed, there was a contract, they used to say, we have a contract, we'll fire you. So hire and fire became the rule, and the persons became poor, and opportunistic trends started, and chaos was there, a lot of revolution was there. And with the result, he, during his tenure, only said individualism as a principle of legislation or as a principle of governance is not good. He went for collectivism, he went for socialism. I'll not talk about it. But the only thing I'll say, that legislation is a science. It should be based on a scientific principle, was propagated by none other than the Bentham, and who was a great jurist in England. And that stands today also, because individualism is a very, very important concept. So now this concept gave us a theory that whenever we are doing a research, it should be systematic. So for research, it should be systematic, it should be careful, it should be diligent, it should be a thorough investigation into a specific question with a primary objective of contributing to the existing knowledge. So whenever you do research, our main objective should be that we are trying to contribute something to the existing knowledge. But what happens? In fact, what we do when we start research, we become directionless. We are not specific in our research. We are not systematic in our research. We merely do surface brushing, and we do not get a result, an inference, which is realistic or accurate in outcome or result. So the conclusion is not good. So therefore, whenever we think of doing a research, and that is legal research, we have got to be very much systematic. We have to be very careful. We have to be very diligent. And a thorough investigation into the specific question which we have chosen, we have to go for it. Now, I will be talking about what is the purpose of research. Now, purpose of research, as I have just said, that it should be to contribute to the existing knowledge in a discipline. Facts can be viewed from different lenses. Now, that is to contribute to the existing knowledge in a discipline. Facts can be viewed from a different lenses. So, from the same situation, person can infer differently. You see, I will be talking about Indian independence only. Persons say that late Mahatma Gandhi's Ahimsa, Satyagraha, and his principle with truth, they have given us independence. Side by side, other researchers, they say that revolt by army led by Netaji Subhash Chandra Bose and other extremists during the independence time, that was the reason where for the independence. We remember that before independence, three years before independence, there was an army revolt, and which was the basic cause for independence. It is said by someone. Even one of the very prominent leader in England confessed that was one of the main reason for independence. And the third cause, which we can easily see, that the establishment of UN, where colonization was not respected. It was said that colonization should be least. So that may be one of the causes. So therefore, same fact situation, same thing, if we can view it in a different way. And that is research. So second can be that to inform the policy making. Now, when we do a research here, normally we are taking socio-economic issues. So we have to look into it, that can there be a specific law on this issue that is reflected in the policy and lawmaking. Now, that is very important, that when we do a policy making research, that is also a type of action research, that we have to look into the law. We have to look into the problems which are faced during the law and how it can be overcome, and do a research on it. You see, I am reminded of ancient time in England as well as in India, that women, they were taken to be the property of the man. And when a wealthy woman used to marry a person, a husband, so her property was considered to be the sole property of the husband. And it so happened, it was found in England and other Western countries that persons, they started finding out the wealthy women, those who are going to inherit a good money, and they used to marry them. Then after that, with gambling and horse trading and other things, they used to exploit that money, use that money, and as soon as the money was exhausted, they used to divorce that woman and go for another one. This has happened in England, and with that, therefore, a law was developed that a woman, though she is the property of the husband, but if she inherits the property from her paternal house, then there should be a separate property, a share in the separate property, so that she can be properly maintained. And that concept was recognized there at the Chancery Court, and it became a principle of equity. So right of women to separate share of her property. So it was recognized, so that even if she is divorced, then she can maintain herself even after that particular issue. So slowly and slowly we have seen now in the policy research that in India as well as elsewhere, the situation has changed. Even the women is having a share in the ancestral property of the parents, and is a very welcoming thing. But how it has come? Because of the policy research. Persons researched on it and said why women should not get a proper share in the ancestral property. Earlier, situations were different. You see, there was a social custom in India that at the time of marriage and afterwards, the lady was given a huge sum of money at the time of marriage, and afterwards also every year something was being sent to the in-laws and to the lady of that particular house. That of course that was not an exact share of the property, but then it was something. But then persons started marrying only those girls who are from rich family, and otherwise they started demanding a huge sum of money at the time of marriage. And then we started saying that it's the dowry. And Dowry Prohibition Act came in the year 1961. But because such a thing was very much prevalent in India, even Mrs. Gandhi once said, Mrs. Indira Gandhi at that time, she was questioned. She said, no, it is a custom. And even my servant, who is there for my personal servant, he has also taken dowry. So because that was a custom, because a share of the property was given to the in-laws at that time. But slowly and slowly, because of the education of the women, because of the development of the women, because of the empowerment of the women, now it has a situation has come where women has started claiming a share in the property of the ancestral property also. A lot of research has been done, and it was said that yes, there should be a gender equality. Why women will not be getting the share in the ancestral property? So the policy was made, and later on the law was amended in the year 2005. And the Hindu law, of course, I'm not talking about the Muslim law. So Hindu Succession Act was amended accordingly. So likewise, things are changing. So this is a type of policy research when we find some defect, some social custom, which are not good, then research is being done therein, and in order to overcome the issues which are arising, the problems which are arising because of the social custom, they are being taken care of, and a solution is found out. That is the type of research which we need in India. And my dear students, you can go for this type of research. When you study at that time, you can study the issues, the problems which are there in the legal system, and then you can do extensive literature review. So for that, I mean, you have to read about the custom, you have to read about the laws on that point, you have to read about the extensive judicial pronouncement on it, and then find out that what can be the solutions therein. And then you can do a policy research and suggest that these are the things which can be done. Now, sometimes one of the issues which we can take in the one of the purpose of the research can be to address specific question or issues. Here again, but what I was talking about, absolute liability principle, a few minutes back I have spoken about, that is issue based. So therein also what we have discussed is that the issue was there that an accident has occurred. Because of that, hazardous substance has emanated, has scattered, has come out, and thereby number of persons have been injured. So for that, so the harm which was done to the public was diagnosed, a diagnosis was done, and then by creating absolute liability principle, it was solved. So legal research can be a systematic finding or ascertainment of law on a particular topic in a given area, an inquiry into the law with a view to make advancement in the science of law. Now, for making advancement in the science of law, there must be a systematic probe into the underlying principle of reasons of law. So until unless that is there, things cannot be done. In fact, I'm again reminded of the same decision, because I'll not talk so many decisions, because if I talk, my time will not be there. So I will be talking about absolute liability principle only. So therein, when Justice P.N. Bhagwati saw that sometimes in such type of cases, entrepreneur or industries of the nature like Union Carbide Corporation with a huge capacity and capability, they are there, and Shriram Food and Fertilizer is there, or else the Delhi Cloth Mill is there. So he found that the assets, the capital of all the three are different. So therefore, he propagated by his research a new type of theory, of course, which was much more criticized later on by further researchers. But that is a different issue. That will be always there. But then he said the amount of compensation should be commensurate with the magnitude and capacity of the entrepreneur. So if a person claims compensation for the same type of escapade of the gas through Union Carbide, he will be getting a very huge amount. But if he is asking for something for a very small company or a small entrepreneurship from where some chemical has accidentally escaped and injured somebody, and because his capacity is not there, so the amount of compensation may be less. So that is what he propagated. Looking into the situation, looking into the problem, he made a very scientific assessment of it, that how it should be done, and therefore he has done it. So in fact, my dear friend, you see, legal research is continuously done by legislators. When legislators, policymakers, they make a bill, and discussions are there on the bill, and when it is passed, so at that time, a lot of research is being done. Our standing committee is there of the parliament, wherein a lot of research is being done on that issue, that whether the way we have talked about Bentham, of course, Bentham theory has not been applied, is not being applied here. Though we are welfare state, we have got our own criteria. But then, similarly, the way he said that greatest happiness of greatest number should be there. Likewise, what will be the impact of this particular law on the people of India? That is fully assessed, and then only the bill is passed. Opposition also does a lot of work to see that whatever lacunas may be there, they point it out and see that they are amended accordingly. So legal research is done by the legislators, by the judges, by the lawyers, by the law teachers, by the researchers, by the policymakers, every now and then. And you law students, I'm happy to say that you are also doing a lot of research. When you take up your project work, what you do? When a project work is given to you, you at that time, you do an extensive literature review on that particular project. And then going through with this, you find out that what are the lacunas in it. I remember one of my students, I gave him a topic of coercion under Section 15 of Indian Contract Act for project work. He did extensive study and came with a wonderful suggestions. Of course, some of the suggestions were given by the Law Commission of India, and some suggestions were there in the various judicial decisions. But apart from that, he has inferred something new therein. So therefore, therefore, you can also, when a project is given to you, you can do a wonderful research, and you can suggest an addition to the knowledge, a new knowledge, or else the knowledge may be the same. The process of adopting it can be different, which you can suggest therein. So, but of course, I understand, my dear student friends, that when you go for legal research, you have got a great difficulty. The difficulty is that a vast majority of statutes which are continuously amended. First thing, there is a vast number of statutes. For a particular aspect also, if you look at, for a particular issue also, for a particular topic also, number of enactments are there in different states. Even central statement, central also a number of, even in different states are different. And then further, they are supplemented by new rules. They are, for one thing is there, amendment is there always, every now and then. Supplemented new rules are being framed under it. Regulations are framed under it. Orders are passed under it. Directions are made under it. Ordinances are made. Judgments are of the courts are made on that particular issue. Bylaws are also there. So I think I understand, my dear student friends, that is a very difficult on your part to go through with all these. But I tell you, my dear student friends, when I was a student of LLM at Allahabad University, long back in the year 1882, At that time, I tell you, you are very much blessed today, dear. You are having the online resources. You are having softwares. You are having a lot of advantage. You are capable of getting on your laptop all the cases which are there in India as well as abroad. You are capable of getting number of journals which are available here on your laptop or in your law school library. Harvard Law Review, Harvard, Yale, Oxford, everything is available to you. Even Australian and everything. But then when I was a student therein, we had a great problem. We were not aware. We had to get we are finding a lot of difficulty to find out the changes in the law. What to say of the foreign judgments, because only few journals were available in the library. We were not supposed to, they were all hard copy. You were not supposed to take them outside. You have to read it there. We had to, for our dissertation, for our study, we had to sit there in the library for up to like 12 to like that, and you have to note down everything. Now in writing a research paper, you see, it is very difficult because you have noted down exact page number you have to cite therein. It was becoming very difficult for us. So now that way you are very much blessed today because you are having a lot of advantage. But further, the law works in a very complex social context. So because law reflects the attitude and behavioral norms and controls and mounts it. So what law does? Law is a behavioral science and norms are created by law. So the attitude and behavior, they are molded by that. And law sometimes says, you have not to do this. This is private. Nowadays, during COVID period, we have all been asked that whenever we are in a company of somebody else, we have to cover our face. We have to keep a social distancing of around more than 6 feet, minimum 6 feet, or even more. So this is a type of behavioral norms which has been prescribed by law, and we have to follow it. So therefore, these behavioral norms, how it can be followed through law, is a research matter. I'm at present, this coronavirus is spreading very fast. But then the reason is that persons are not obeying the behavioral norms set by law. But then we have to see that how these norms can be implemented to the every member of society so that we can overcome the coronavirus. You see, India is a very fortunate that we are having it, our brain well developed. We are intelligent people, but because we are perfect in Yugal, how we will manage situation we know very well. So, but what is happening? These jugars we do, but we do not stick to it. We do not research over it. Otherwise, if you do research on it, a new knowledge will certainly develop. We do a jugaad, we when the work is over, we forget it. So actually in India, the research has suffered. There are various reasons. One of them we have already discussed, that we followed the colonial era rule. We did not suggest any new rule for us. You see, we are a democracy. Democracy means a law, a government by the people, for the people, of the people. That means The people are sovereign. We are the lawmakers. So law should emanate from us. My dear student friends, is it emanating from us today? Of course, you can say, yes, sir. The thing is that we select our representatives. They go to the parliament. They discuss it. They vote for it. So yes, it is coming. Indirectly, it is. I agree with you. But then, do they suggest you what you want? What you want? What the people of constituency want? What the people of the country want? Do they consider? Is there any mechanism by which you can tell the government that I want, everybody can tell the government that this is the type of law we want? We have not developed it. We are having only indirect method. Now, this is the era of information technology. Earlier, it was very difficult. But now, in this era of information technology, things have become simple. Somebody has to work on it, find out a solution, so that when a law is passed, it should come to our knowledge on the online, and we should do research on it, and then represent ourselves, our views therein. So if a law will emanate from the society, then law will be followed. Here, the laws are of the colonial base, and then the legislations are made in English or Hindi. In other languages, people do not know. And ignorantia juris non-excusat. Ignorance of law is no excuse. So they are not excused. They are supposed to know the law. So these are some issues over which you are a young brain. I feel I'm talking to you so that you can work upon it. You can find out a solution. Here you can find out how it can be overcome. Nowadays, when the law comes in, how it comes in? India goes to some foreign country, to some conference, some treaty, signs a treaty. Treaty obligation is there, and because of treaty obligation, laws are made. Most of the laws which are there for human rights and other, are for market economy and other things. They are based on some treaty or the other which India has made, some conference or the other which India has signed and adopted and ratified. So that is the way the law is made. But of course, what is where does our interest lies? Nobody talks about. Anyway, so now I'll be talking about further. So norms of society are changing with time and space. So it is desirous that the law to adopt and be dynamic in order to cope up with the changes in the society. So law should be based on societal norms. Law should depend upon the public. And so that is what I was beginning to say. It is desirous that law should be adopted and be dynamic. So in order to cope up with the changes in the society, therefore, legal research to become essential. It should be for the ascertainment of law. Now, to point out ambiguity and weakness, to critically examine the law in order to ensure coherence, consistency, stability of law, and underlying principles. So here, when you examine the law thoroughly, then you have to see that the provisions they are in coherence with each other, they are consistent with each other, they are having stability in it or not. And whatever law is there, my dear friend, it is we law teachers, law students, who have to see that a social audit of the law is there. we have to go for the social audit of the law. Now, when I talk about social audit of the law, I've just discussed a few minutes back that what is the social audit of the law? We have to look into earlier, when the law was made, what was the situation in the society. So pre-legislative history has to be understood and appreciated. Then social factors that has impacted in making up this particular law should be taken care of. And then we should, then in that context, we should see what law intend to protect. And now, in these changed circumstances of the society, what changes should be brought in that particular law, and what is the reason for those changes. So this audit helps in identifying the gaps, if any, between the legal and social reality, and to know that the reasons thereof. It predicts the future of the law. Now, I will be discussing with you one simple example to understand this. You see, you must you have in your first year of LLB of law, maybe BBLLB, BLLB, become LLB, BTech LLB. You must have read section 3, section 4, and section 5. Now, when you talk about communication of proposal, communication of acceptance, what does it say? The communication of proposal is complete as soon as, in England, as soon as it is posted. At that time, there were only 3 modus operandi. One was by face to face. The second one was by letter, by post, and third was by telegram. Of course, messenger was a face to face method. So there were these 3 messages. So when the letter was posted in England, immediately it was taken that the proposal has reached. And similarly, when the acceptance was posted in England by the acceptor, it was taken there that it has reached. But then what happened in India? They changed it. Why do they change it? We have to understand that social reality. In India, a proposal is communicated to the other party when it comes to the knowledge of the person to whom it is made. So if a letter is communicated, if a letter is posted, at that time it is not complete. When it is completed, when it comes to the knowledge of the person. Supposing you want to purchase a laptop from your friend at Allahabad, and you send a letter. So your proposal will be complete when your letter will reach Allahabad. Your friend will read it and come to know of it. But in England, as soon as letter is posted, it's complete. Similarly, when your friend accepts the proposal and posts the letter in the letter box, then only the acceptance is there. Whether you receive the acceptance or not, is immaterial. But in India, it is not there. Acceptance is complete as against the proposal when it comes to the knowledge of the person to whom it is being. So when you come to know of, when the letter comes to you, you open it, you read it, you know the content, then it's complete. Why this change in Indian and English concept? You have to read, you have to study. This is what the research you have to do when you do it. You read Anson's law of contract, side by side. Indian mullah on contract, or for that matter, Avatar Singh or any other book on contract. Then you can find out. You have to do research. Why this change? The change is because in England, the postal department is taken to be the public service department and the agent of the public. Whereas in India, we were in the colonial era. We were subjugated. We were not independent. How can how can the postal department, which has been established by Britishers in India at that time, be the subordinate or agent of mine? How Indian will become the master and it will become the agent? No, not possible. And therefore law was changed. But though the law was changed, but then it was not properly implemented in India also, because English principle law was applied by the various judges here. They were English people. Anyway, now in the year 1966, you remember, because I'm giving you this example, because you only can understand, the social audit through this. That in Purushottam Das Kedia case, if you remember, a phone call was there for one person to other, and the phone went dead while the acceptance was made. While acceptance was propagated, phone was all right. When the acceptance came to the other party, it became dead. And he could not understand, and therefore the problem came up. So the interpretation of the section 4 and 5 was changed accordingly through social audit. So likewise, when you study, you have to also do this social audit. And when the email came, e-contract came, then it was found that Indian Contract Act e-transactions are e-contracts, and therefore information technology was made. So these are the research, how it has come up, because many persons, they conducted research on e-transactions, e-contract, and felt that this particular law, they did the social auditing of Indian Contract Act. Section 3, 4, 5 are not properly applicable in case of e-contracts. There another concept of acknowledgement was added, that not only because at that time the emails will reach or not, we were not very sure. We were as an infancy stage of information technology. Even today, I tell you, my laptop was working, it has a very good network. But then all of a sudden, what I found, that when it became 450, network problem. Now I have to speak to you on my mobile phone. So these problems are there. So we have to undertake this social auditing of the law to identify the gaps, if any, between the legal and social reality. This is where your work comes in. You have to do the social auditing. This social auditing is very important for you. And while you are doing research, take projects in such a way that you are doing the social auditing of the law. That means to identify the gap, whether the law is properly applicable to the society, to Indian situation or not, whether the law fulfills the purpose for which it is made, whether the law needs a change, or there are big gaps which has got to be fulfilled in, like in case of e-transactions, Indian contract was applied, there was a big gap. So therefore, immediately Information Technology Act was enacted. So these things we can do. And here, with regards to adultery, you have just seen how the law has been changed by the Supreme Court. The reason was that a lot of research work has been done by students of different law schools, by different law professionals, and they were of the opinion that adultery law is colonial law and it should not be applicable, because it has taken, the reason was that women was taken to be the property of the husband, under the adultery law under Indian Penal Code. And therefore, it needed a drastic change. And therefore, Supreme Court, 2 years back, it has said that the law is unconstitutional because it treats women as the property of the husband, which was there in ancient India or in ancient British people some 3 centuries ago. Now, situation has changed. So, say regarding the situation, reforms are needed. Now, the court has only said that is unconstitutional. So, what should be the law in fact? Should it be totally abolished? Or should there be some changes made? This is your jurisdiction. Do the social auditing of the law and find out these are the loopholes, even by declaring this as unconstitutional. And therefore, some law should be developed. So, now I will be talking to you because much of time I have spent. So, I will be talking to you on the process of legal research. The first and the foremost thing is that whenever you do go for research, you have to identify and formulate the research problem. Normally, in many of the law schools, I find that the project topic is given by the faculty. In fact, faculty should not give you the project topic. They should encourage you to search a project topic by your own so that you can go through with the provisions of law, you can go through with the cases, you can go do the social auditing of the law, and then find out where are the loopholes. And knowing those loopholes, you can identify these loopholes. And keeping that thing, you should formulate a research problem, and then you should go to the faculty. Sir, I want to take this topic. My research problem is this. I have already identified and formulated the research problem. But for that, I tell you, my dear student friends, what you have to do. You have to do extensive literature review on that topic. I just told you what is literature review. You have to read the law. Now what we do normally when we are given, we have to read Indian Contract Act. So we take a Bare Act from which has been published by someone. Is it a primary source? No. You go to the Gazette notification and get the original draft of the law. Read there. Read that. And supposing you are dealing with the constitution, read the Constitutional Assembly debate on that. You will get that real concept. And then after that, go through with the various cases which have occurred on that particular issue, one by one, systematically. You will find that how this research problem or other research problem in that area have been solved. Now, from therein, that how those have been solved, similarly, you can apply that, how you can solve it. So now, choosing a focal point for the research, first is the thing. Now, researcher has to set a goal. I told you. You have to go for the issue, that this is the goal. This is the thing I want to do. Now, researchers and how will you go to the goal? First of all, identify your interest in a general interest. Supposing you say that you are interested in criminal law, IPC, all right? Then you should go. The criminal law IPC is a very big, having 511 sections. So many things are there. So what you want now? So for that, you should start reading. And then you see, oh, this adultery is having some problem. So now, from a general interest to a specific interest, adultery. Or else you can go for sudden provocation under right of private defense. So from general interest to a specific interest. Now, in specific interest again, you have to find out an issue, a research problem. So a particular aspect of the issue which you wish to inquire. Until that is what, that identifying that particular issue which you wish to inquire, and then formulating that research issue is very important. That will become your research problem. And that is very, very important for you to go ahead. Now, the second thing is, which most of the books say, but I have told you already, that is the formulation of the review of the literature. You have already done it, because without review of literature, you cannot find the research problem. You cannot identify and formulate the research problem. Then further, you have to deal with it and discuss and come out with an outcome of research questions. So you have to formulate on that problem some questions which are very relevant, which are pertinent to them. So formulation of research question. And supposing you are a student of PG doing your dissertation, or else you are a student of, you are a researcher, research scholar, are a faculty, are a great researcher, then side by side you have to formulate hypothesis also. But because today I'm not in a position to discuss with you the formulation of hypothesis, and for you student, normally most of the law schools, they say that hypothesis is not that important. You have to formulate the research question, that is sufficient. Now, after doing that, you have to see that if you are working on that field, are you going to develop some knowledge, and whether that knowledge is beneficial to society? So aims and objective of the research, whether it is beneficial to society or not, that also you have to discuss. Now, further, you have to go for the scope of the research with limitations. So supposing you are doing on a particular work on a particular research topic, then you must know that what are the limit, how you will, what are the issues therein, how you are going to go ahead with, how it will be tackled, and what are its sphere areas with which you have to concern, and further what are the limitations which you are going to go ahead with. And then once you have formulated your research problem, then you have to think of by what way you are going to do it. That is the research methodology. Research methodology normally has been divided into two types. Of course, other researchers are there, other faculty members, other experts are there. They will talk about the types of research, because my time is not there to discuss with you the types of research. So research formulation. So here, what you have to do is that you have to divide it into two, either the doctrinal method, where you use primary or secondary data. That means primary data means what has been enacted by the parliament statutes and the law itself. And in the secondary, you get a lot of things. So primary and secondary data, of course, whatever you find yourself, that is also there. So you can find out that. Now, two types of methodologies are there. Your other experts will tell you. Now, interpretation, there are further with this methodology, how you will collect the data, and how will you interpret that data, and after interpreting those data, how will you formulate a conclusion from that? That is very important. So that you can apply questionnaire method, you can apply that interview method. There are different methods through which you can formulate it. You can go ahead with. So in this way, we can say, then further, after that data has been analyzed, then inference will be there. From inference, you will draw conclusion and suggestion, and then you will be writing your research report. So research is an art of scientific investigation, a movement from known to unknown, a voyage of discovery. So this is what I had to discuss with regards to concept of the research. Now, I will be talking to you something about the academic integrity and plagiarism. So I will be in the other slide, madam, it is there. With the other slide which is there given by Manish, that is there. You see, my dear friends, the slides which I am presenting before you are not mine. I have not made it. I have asked some persons to make it. I'm old man. For me, making slides is a little difficult. So my other friends, I have been very much indebted to them. I told them this is what I want to speak. So they have made the slides. And if you want, then you can ask the organizers. They will provide you these slides. I've got no objection to it. Further, my dear friends, I request you that if you are interested in research method and techniques, then you go to your YouTube, and therein, ICFAI University, where I'm dean, has conducted a 5 days workshop on research methodology and techniques, wherein Mr. Manish, whose slides I'm using, has wonderfully dealt all these things in detail. And if you go through with them, it is available on YouTube. You have just right therein, search therein, 5 days workshop on research methodology and techniques by ICFAI Law School, Dehradun. It was there in the last month, in the month of June, and therein you will be getting a good knowledge about the research methodology and techniques. So I suggest every one of you should go for that. So now, what do you understand by plagiarism? Why it is important in research? Because if you plagiarize, then you have not done the research. So ethics says that when you do a work, it should be your own. When you do a work, it is your responsibility to do it. You should be honest enough to do yourself. You should not represent some other's work. Yeah, the way I have done it here, that I am representing a slide of somebody else. That is plagiarism. I agree. But my dear friend, they have done it for me. So that way it is not plagiarism, because they have worked. They are very good friend of mine. They did it for me. So I'm indebted to them. So it is not plagiarized, because I'm not saying that is my work. If I say it is my work before you by cutting their name, then it will become plagiarized. So plagiarism is normally copy and paste. What we do, we copy, we cut and paste. So without reference and acknowledgement. So if we do that, it is a plagiarism. So plagiarism is an act of presenting the work of another as your own. So plagiarism is the work, is the act of presenting somebody else's act, somebody else's work, somebody else's research as your own. If you do it, then you are plagiarized. Then you are doing plagiarism. Now, plagiarism may happen. How? Sometimes I was One day, one student came to me and has shown me that the article which he has written, word by word, some person has copied it. So from word by word copying is there, but another word. And that means it is fully plagiarized. Now, paraphrasing. This is very common. Almost everywhere this goes on. What persons do? They read somebody's article. Then they change the word. They go for thesaurus. They go for some tools, grammar tools, and other tools, language tools, which are available on your software. And they apply little brain. And then the work of somebody else, by change of the language, by change of the language, is represented as his own. He says, no, language is mine. Idea may be different. But then, my dear friend, that is also plagiarism. So please remember, this is being done by many of my students everywhere, not only my students, in almost all my schools. That paraphrasing is very, very common thing. You retake that. Some persons, they take the article of some other person, and then after that, they do paraphrasing. They change the language. Ideas are there. Ideas are his. Language is changed. Grammar is changed. Words are changed, and they do it. Now, sometimes, of course, in your research work, in through your literature review, you will certainly be taking some ideas from somewhere. So if you take some idea from somewhere, then your duty is to cite the source, cite the reference. If you cite the reference, then you are not plagiarizing. The way I told you, these slides have been made by someone else for me, and I'm telling it to you directly. So that means I'm not plagiarizing. But if I do not tell you, and then I present before you, yes, it is plagiarized. Now, further, failing to act properly by citing the sources. So what happens? It is a very, very common thing, I tell you. Students will come to us with their project work, with their dissertation. And in that dissertation, references will not be there. Or only little bit of references will be there. They will be writing up something of their own. Then we'll say, oh, these things have no references there, no references there. No, for these things, reference should be needed. They will go and do what? Without going to the actual reference, actual source, some source on some topic, somebody has spoken, some article has written, they will cite there. So they will not properly cite, they will cite something. So that is also plagiarism. Acha. That means attributing information to a source from which it did not come. Submitting a work cited by another and in his own name, that is a plagiarism. Another issue comes in, you see. Supposing you have started working with 2 or 3 students, started working on a project. You have also done it. You have also done research, but your friends have also done research. After a few days, you represent the whole work has been done by me. Don't cite the name of your friends. Then that is plagiarism. Now, further, I'll be talking to you why plagiarism happens. Why people do the plagiarize? Why persons go for plagiarism? One thing is, as rightly said, you are given project. You are having 6 subjects. In all subjects, you are having projects. Now, throughout the year, you did not do anything. Last date for submission of project came up. Now you are having time constraint. What to do? Get something and submit. So you plagiarized. I'm not talking about you. Some persons, they plagiarize. This happens. Now, Many students, they have not read, they have not gone for research skill. They do not have knowledge about the research methods. They have not gone for literature review. So they do not know how to do it. They have to plagiarize. Sometimes student has done very well, but he's lacking confidence. पता नहीं मेरा काम अच्छा है कि नहीं है, पता नहीं मेरा काम पसंद आएगा नहीं पसंद आएगा, वो काम अच्छा है, उसको लोगों ने बहुत अप्रिशिएट किया है, उसको दे देता हूं मैं. तो lack of confidence is also one of them. Then further, ignorance and carelessness about the many of the students. They have ignorance, they are carelessness. As I told you, research is a process where carefulness and diligence, honesty, integrity, these things are very important. If you do not do it, then naturally the work will be plagiarized. Now, sometimes there is a pressure from the peer groups, pressure from the supervisor, pressure from the society. You are working something for the society. So they said, no, you have to submit it now. Supervisor said, no, tomorrow you have to submit. You have not done the project work. What you will do? So these are some of the regions wherein plagiarism is there. Now, further, I can talk about the types of plagiarism. Types of plagiarism are direct plagiarism, word by word, self-plagiarism, that is use of your own document. This is also a type of plagiarism which you feel how it can be. You have written a good article. It was published in a UGC Care Journal. You are very happy with that. Now what you do? You take matter from there, change the name or something. You do some little paraphrasing and submit it to somebody else. And say it has not been submitted to anybody else. Because you say this paraphrasing has been done. So that is self-plagiarism. Now mosaic plagiarism is phrases without quotation mark. You put the phrases. You put the way I was talking to you, the decision of our Justice P. N. Bhagwati. I say, but I write it there, but I do not put inverted commas, I do not quote. Then it is mosaic plagiarism. Accidental plagiarism is there. Sometimes you have done a lot of work. What has happened? Citations. You are having number of citations. You have forgotten the citation. Citation, because you have not forgotten, you have forgotten. So some citation which should have been for the other work, you put it for some other work. So there it is a type of accidental plagiarism. And that is also very common. Because when you have to write, if you are not systematic, then you will not be keeping things in track. And at that time, you will have to provide references. So while providing references, you may be having that issue. Now, anti-plagiarism tools. You see, there are number of tools. Madam, next slide. Yes, there are number of tools which is shown it here. But then I'll not talk because my time is almost over, and you must be feeling bored. So I will be talking only two. One is the Turnitin, which is available in almost all institutions which are recognized by the UGC under 12B or 2F. So Turnitin is there. Another one is Urkund. So all her education institutions, they are at least provided with Urkund. So these are the two anti-plagiarism tools. But do they tell you what is plagiarized? No. They just tell you similarity index report. They give you how much similarity is there to some others. So that is the similarity index report. So depending upon the policy of the institution. Now, how much similarity index report can be permitted? So this is based upon earlier it was based upon the institution concerned. How much plagiarism is accepted? Actually, it is accepted 0. No plagiarism should be there. But how? Because our name of the act is same. The citation which we give is the same. The principles are the same. So naturally, some similarity index will be there. So therefore, the next slide will be telling you where that. Madam, we can go to the next slide because I'm a little going ahead. Yeah, another slide is also there. Madam, go ahead, please. Actually, I'm dropping it. No, this one. You see. So up to 10%. If the similarity index is up to 10%, oh, there is no penalty and it's a minor similarity and it is accepted. 10 to 40% similarity is there for students I'm talking about. That then such a student is supposed to be asked to revise his script and bring it below 10%, and he is given normally a time of 6 months to provide it. Now, level 3, it is under the level 3, it is 40 to 60%. Now, in this case, the student is debarred for 1 year and is asked to submit again. And above 60%, his registration in the institution is cancelled. That is the position. Now, where you can get this University Grant Commission promotion of academic integrity and prevention of plagiarism in higher education institution regulation 2018, it talks about. So for teachers also, another is there, which is there for teachers also. So there also the panel, the plagiarism is there, and they can be penalized also, they can be punished also. So every department, every law school should have academic integrity panel, and every institution should have academic integrity panel. Like ICFAI University is having 4 schools. So every school, my law school is having its own academic integrity panel. Side by side, university is also having its own academic integrity panel. So the slide which I have provided, it is having. So now I feel that my time is almost over. So with this, I can simply say that if you follow the principles which I have discussed today with you with regards to the research, with regards to methodology, with regards to the processes which you have to follow, we have given you that how, first of all identify the problem and then go ahead with, if you are then research question, then objective, the aim and objective, then the scope, like this you follow, and you abide by the anti-plagiarism norm, your research will be certainly wonderful and you will be capable of doing a good research. With this, thank you very much for patient hearing. Madam, some questions are there, I can answer.
Sure, sir. I'll be, if anybody has any question, they are requested to raise their hands and we would be unmuting them one by one.
Achha, and apart from that, madam, you
Yes,
kindly, you can provide these slides to them. I don't mind.
Sure, sir.
And side by side, I have given, you can ask them that ICFAI Law University, ICFAI Law School, ICFAI University,
yes, sir,
has organized 5 days workshop on research methodology and techniques, wherein in very detail we have discussed everything. So perfect. It is available on YouTube, and it was there just 2 months back. So they can go through with this and read about, because many things I could not cover because of the time constraint. And madam, thank you. If some question is there, I will be happy to take up.
Yes.
Ms. Netri is there. Please.
Yes.
Hello, sir.
Please.
Sir, yeah, you were speaking about the plagiarism checker, right? What was the best one apart from the Akund one? Akund one.
You see, all are from different countries, and so it is very difficult to say the best one. Depends upon the type of research you are doing. But of course, Urkund is quite good.
Thank you, sir. Sir, there's another question from one of the participants. He wants you to elaborate on the formulation of hypothesis, like how to formulate one hypothesis while presenting a research.
So you see, I'll not go in much details, but the thing is, hypothesis is a statement with variables. So what happens actually when you go for your identification of the problem and thereby formulate the questions. So the questions are formulated in such a way that there are connectivity of 2 or 3 variables. And once you are capable of connecting them with 1, 2, 2 or 3 variables, or which variable means over which you can do research, or which is not certain. So if you can do that, then hypothesis will be very good. So normally at the level of graduation, hypothesis is not asked from students. Research questions are being asked. That is why I did not deal in detail with regards to hypothesis. But hypothesis is a very important component if you want to do a good research. And therein a statement is made wherein that statement which you can verify through your data. So that statement is called hypothesis. If one is there, hypothesis, more is there, hypothesis. So that is there.
Thank you, sir.
Good evening, sir.
And another thing I can tell them because tomorrow you will be having a class wherein different type of researches, legal research will be taught. So for different type of legal research, hypothesis can be different. So you can ask them. And apart from that, the source which I have given you and the source which I have talked about is on YouTube. You can go there and you will get it.
Good evening, sir. I would like to ask you, after completing the research work, how to publish that?
It is very simple. If your research work is genuine, it is not plagiarized and other things, you send it to any journal, because research means you have formed, you are having something new, some new concept you have developed, new process you have developed, new knowledge you have developed. That knowledge is helpful to the society. And if these criteria which you are talking about is fulfilled, I tell you, if you send it to any journal, they all will be very happy to publish. The only thing is, in my country, that because of the language problem, many of students they do paraphrasing. Others work, they change it, and they do not their own research. Once you do not do your own research, your reasoning will not be proper. And your reasoning will not be proper means it will not be published. Once you do your own research, then you know your reasoning will be very proper. Your content will be very proper. And it will be certainly published. Even all journals will be very happy to publish. Anybody else, please?
Sir, I suppose there are no other hands raised. So, okay, so the participants are requested to take the note of the following things, as sir said. 1, the PPT shall be shared to everyone via mail post this session. And secondly, the participants are requested to go through the YouTube link of ICFAI Law School, ICFAI University, wherein they have discussed in detail about the research methods and research methodology in order to complement today's lecture by sir. Now, I, on behalf of the entire team of INLR, Law Learners, and the Center for Legal Research, RJNLU Patiala, thanks, sir, for investing his precious time with us and interacting with the students one-on-one. It was indeed a very wonderful lecture, sir, and no one else other than you could have been taken it in so detailed yet precise manner. So I thank you on behalf of the entire team, and I hope you also felt nice taking this lecture. And I hope for further such collaborations. With this note, I thank Sir once again on behalf of everybody, and happy Gandhi
Thank
Jayanti,
you, madam.
sir.
Thank you very much. You have given me an opportunity to speak before the students, but of course, because of my laptop problem, I could not see them and I could not properly do it. And but then anyhow, I feel that they could hear me properly. I feel like that. Okay, madam. Thank you very much.
Yes, sir. Yes, sir. Thank you so much. Thank you.
Okay, thank you.